this module, we're going to be looking at the common trademark mistakes that trademark trademark owners make, and how you can avoid them and just have a smooth registration process all the way. Because the thing is, if you're making mistakes in your trademark registration, that could cause you to lose money, because if it's not well done, then it cannot be well protected. You can quote me on that one. All right, so let's get started. The first mistake is even in the name themselves, choosing a weak or generic name. So the idea of a trademark is to protect a name that you alone will be able to use. So choosing a name that is already generic kind of defeats the purpose of that. So for example, if you have a bakery, for example, and you want to say Sweetbread Bakery, that might not be a trademarkable name, because bread is a generic name, and to even make it worse, it's in that same business. It's the bread, in the bread business. You can't really exclude every other person from using sweetbread, and so picking that kind of weak name is not in your best interest. And I've usually had to advise clients when they come to me with weak and generic names, because I know that even if we go through the process, first, we're not going to get through the process. And even if by any chance we get through the process, it's a weak trademark. What is a weak trademark? A weak trademark is one that is not strong enough that it can prevent other people from using it. And so what's the point of having a trademark if you cannot prevent other people from using the name? So a weak trademark is one that people can easily counter to say, oh, it's too generic. You can't really take control of that name. So, okay, I have on my slide, Nice Bakery. Like, it's too generic. And the thing is, one of the rules of trademark is that for a name to be trademarked, it has to be something that is not descriptive of what it is. So, for example, the sweet bread I talked about, you can't run a bakery or a bread business and call it sweetbread. You could call it that, but it's not a good trademark. You would not be able to get an approval on that. And even if you do get an approval on that, it's not strong enough. So you want to choose a name that is distinctive, that is unique, a name that stands out. That is how you get a strong mark that you can deter other people from using, that you can actually prevent other people from using. And in the description of this video, I'm going to have a free checklist of some of the things that you should consider when choosing a name. So I've had to really go back and forth with clients on this, because clients are really attached to a name that is generic. And for me, it's just like, if you don't need a trademark for this, if it's such a generic name, because you're not going to be able to prevent other people from using it. And that is one of the essence of trademarks. And still speaking on choosing a weak and generic name, like I said, some names would just not fly. Common names like orange, pink, those are colors. Maybe if you're in the color business or something. And let me also clarify, just so that you understand this correctly. When I say a generic name, there are instances where you will be able to use a generic name and it will not be termed generic name in that context. Before I explain this, let me just give you an example of it. For instance, apple. The renowned apple that you know. Apple is a generic word. It's a fruit. But Apple is able to have a trademark for its name, because it's not in the fruit business. So if it were in the fruit business, for example, then it would be a generic name and it will not be acceptable from even the get-go. But because the name Apple, although it's a generic name, although it's a common name, it's not sought to be protected in that class. It is sought to be protected in a business that has absolutely nothing to do with the fruit apple, right? So that's a way I can maybe get a trade name of a generic word in a specific business. So that's why I can maybe have a business that I will be able to trademark the name purple, maybe Purple Homes, because purple is a color, and maybe in the business of real estate or hospitality, it's not generic in that sense. So I hope that this is clear in your mind, and just so you understand what I mean by a weak and a generic name. So what you want to do is avoid choosing a name that is generic in the business you're doing, because that doesn't work. Another mistake that would-be trademark owners make is failing to conduct a trademark search. And one of the reasons for this is it just depends on maybe if you're using maybe an ad, or if you're using someone who is not really vast in trademark registrations, who just goes ahead with the process of filing without doing a search. So if you're skipping the trademark search stage, it can result in you, number one, infringing someone else's trademark, and number two, just causing you to use a trademark name that would not even go through in the end. And in that case, you would have lost money. So if you're conducting a search, you should conduct a search, not you now, the person who is, or the attorney or the agent helping you out with the registration process. They ought to conduct a proper search to avoid infringement, which can take heavy financial toll on you and just really stress you emotionally as well. So conducting a trademark search sets you up for success. To avoid this, what you want to ensure is that what you want to do is be sure that a trademark search is conducted and in the relevant class before proceeding to file. And if you are registering your trademark with us, this is not a step that we skip or take for granted, because whatever the search result gives us is what determines where we go and how we counsel or advise clients to move forward. So you want to be sure that you're not skipping this part. Another mistake that would-be trademark owners make is delaying the registration of their trademark. Delay is dangerous. This is one of the cases where delay is dangerous. Honestly, this is one of the cases where delay is dangerous, because if you wait too long, someone else may register your brand name first, and that means that it is gone. And I talk about this right now. I am actually dealing with a client who reached out to us to help with their trademark registration, and turns out that the trademark that she intends to use is already, at the time that we did the search, we conducted the search at the trademarks registry, we found that the name was already in use in the class that she wanted to use the name in, and we had to report back to her and just advise her on next steps. And she was already so attached to the name that it was really hard for her to let it go. She didn't want to let it go. But I knew that we could not proceed from there. Unless we wanted to then reach out to the trademark owner and maybe contest that. But I just knew that it was not a battle that I was going to advise her to fight, because the odds were against her in that case. And I did feel sorry for her, but we're still, as I speak, in the process of trying to get a new name going forward. And she's just so disappointed and sad at the turn of event. And you don't want this to be your story. If you conduct a search, and that's one of the first things that we do, if we conduct a search, you should file your trademark right away, honestly, before someone else does. Because even if you're going to negotiate a license with this person like that, you don't have the kind of control that trademark should give you, So you just want to be sure that you're registering your do not delay. Do not delay. As soon as your trademark search comes out with a clearance pass, with a green mark or with a yellow mark that you're ready to proceed right away. Proceed right away, and do not wait any longer. Now let's talk about this mistake that people make. Registration in the wrong trademark class. This is really destructive. This is not good. You don't want to be in this case. So there are 45 trademark classes currently under which you can register your mark. What does this mean? And I should say that a registration in one class does not offer for protection in another class. So there's classes 1, 2, 3, 4, 5, and up to 45. And your business or your service will fall in any one or more of these classes. If you're filing under the wrong class, that will inhibit your protection, because the only class you can lay claim on is the class in which you were registered. So if you're registered in the wrong class, that is like taking a flight to Lagos when you want to go to maybe Kaduna or somewhere else. It's running in the wrong direction, like you've successfully run a race in the wrong direction. And I should also say at this point that in a case where you want to register, or where your business falls in more than one class, then yes, you want to register in those multiple classes to get the best protection for your business or for your trade name. So how can you avoid the mistake of registering in a wrong trademark class? It is consulting with a trademark attorney, someone that has experience in the field of trademark. They will advise you on the right class or classes. And at my law firm, Omolereabisola Law Firm, what we do is advise you on the right class based on the information that you provide to us, and we further share the classes with you just so that you can also see for yourself if you would like. And this step is really important because this is the foundation. You don't want to build a skyscraper on a sand, it's a sand castle. You don't want a sand castle for your trademark protection. You want strong walls. And so you have to start right. Another mistake that would-be trademark owners make is not registering in all relevant classes. And just like I talked about the last minute, the different classes of trademarks, and trademark rights are limited to the classes that are registered in. Trademark rights are limited to the classes that you register in. And this is a kind of misconception that, and there is the misconception around trademark is that once you have a trademark in a certain class, then you can prevent every other person from using your trademark. That is not the case. You can only prevent people from using a mark in the class that you registered in. And that is why if your business falls in multiple classes, then you want to have a trademark in those several classes. So if you don't register your trademark in all the relevant classes, others can use a mark similar to yours or even the same as yours in a different class. And that was the case in Subaya and Toyota case on the Lexus brand. Just to summarize this case, so Subaya had the trademark Lexus in, say, classes 9 and 11, and Toyota applied for a trademark in class 12. And so Subaya is saying, no, you can't use the Lexus brand. We have the Lexus brand already. But guess what? Subaya did not have a Lexus trademark in class 12, which Toyota wanted to register in. So what do you think was the verdict at the end of the case? And the case actually got up to the Supreme Court. And, it just reaffirmed the fact that if you want registration, if you want protection in multiple classes, you have to have a registration in those several classes. Otherwise, you cannot prevent other people from using your mark in other classes that you have not registered in. So, and then one useful tips that I'll recommend is you have to think beyond your immediate business, and this is where some businesses use, a defensive trademark strategy. And what is a defensive trademark strategy? It's just what allows you to look into the entire scope of your business, maybe just looking into your business right now and also in the nearest future to see where it's going, and then thinking about the classes that your business or service falls in and registering a trademark in those classes even before you get into it. Now, some jurisdictions don't allow this because if you're registering a trademark, you have to use it. You have to be using it, But here you can have a defensive trademark registration and think beyond your immediate business. This is a very, very common mistake, and I see it over and over again. Abandoning your registration halfway. So you're going to see, once we get to the part of this section that talks about the stages of registration, right? There are different stages of registration, and we'll talk about that in another minute, just so I don't go ahead of myself. But you want to be sure that you are not abandoning your registration halfway. A lot of people stop at the acceptance certificate. An acceptance certificate, which is a document that you get from the registry, from the Trademarks registry, stating that they've accepted your mark and that your mark will be published in the journal. That is a starting point. That is a good starting point, but that will not get you there eventually. What you want to have eventually is your certificate of registration, that serves as conclusive proof that you have the mark. And an acceptance certificate will get you started, but it will not take you there. And what do you want to do? You want to follow up with your trademark attorney to complete registration and obtain your certificate of registration. Another mistake that would-be trademark owners make is, the wrong assumption that CSE registration offers trademark protection. I see this one over and over again, and I don't know, I try to talk about it all the time. So let me talk about it again. That CSE registration is entirely different from the trademark system. The CSE registration process is governed by the Corporate Affairs Commission, and the trademark system is governed by the Ministry of Trade and Investment. CSE registration does not grant trademark rights at all. What CSE registration does is recognize that you are in business, and that's all about it. If you have a business you're running, you should register it with the Corporate Affairs Commission. But if you want protection over the name of that business that you're doing, a CSE registration is not going to do it for you. A trademark registration is what will do it for you. So a business name only allows you to operate legally, while a trademark is what gives you exclusive rights to the name of your business, to the name of your brand. It's interesting, and that's what happened in the Sanofi versus Nigerian companies case. Again, just to keep this really simple, Sanofi was a company that it wasn't even a Nigerian company that had a trademark of a certain name, right? And some Nigerian companies decided to register that trademark of Sanofi, or that trade name of Sanofi, under CSE. And Sanofi was not happy with that. And so they reached out to the CSE to ask them to direct these Nigerian companies that was now infringing on their trade name to change their name. And guess what happened? The court held in their favor, yes. So if your trademark is being used by a company name without your consent, you can enforce your right, to ask them to change it. That means you have the option of reaching out even to CSE to direct those companies, because, the company is registered under CSE. So while you could reach out to the company themselves to let them cease and desist from using your name, you can in fact reach out to CSE to direct them. The law provides for that, and CSE recognizes that. So what would I say about this? Before registering your company name, and the thing is, at our law firm, Omolereabisola, we also assist with company registration. And one of the things that we even offer at that point while we're registering companies is to conduct a trademark search, just to be sure that there's no conflict. The company's name will not vitiate, that the company's name will not infringe on an existing trademark. And I actually really wish that there was a system that kind of automatically, ensures that. But as at right now, there isn't. So it's just a step that we take. It's a proactive step that we take to ensure that even any company we're registering is not going to infringe on an existing trademark. And then we advise that new company to then trademark their mark, just so that they can truly own it, because you don't truly own a name from CSE. So what is the key takeaway from this section as we wrap up this section? Registered trademark takes priority over company names with respect to trademarks. And that should be no-brainer. I mean, the court has upheld that a registered trademark outranks a company's name under Nigerian law, so that if a name conflicts with a prior registered mark, it can be ordered to be changed. What does this mean for you? So think about the company that you currently have, the company name that you currently have, and see if is it possible that you are under risk that a trademark owner would come after you? And also, one thing you can do is maybe after this section, you can reach out to us to conduct a trademark search, and then you can just take it from there. Another takeaway from this is that CAMA, that's the Companies and Allied Matters Act, which is the law that governs the Corporate Affairs Commission, is that it acknowledges this outranking. So the CSE has authority to compel a company to change its name if it conflicts with an existing registered trademark or business name. And then you can see that under the sections 852 of the CAMA, that empowers a trademark owner to object to a company name registration if it is identical or misleadingly similar to their mark, or likely to cause confusion among consumers or customers, or it violates an existing trademark that they have or their business name rights.